arbitration. Let's talk about what arbitration is for those of you who are not familiar. It's essentially an alternative to settling a dispute in the court system, whether that's the state superior court system or the federal court system. It's an alternative because you would be in a conference room as opposed to a courtroom to hear the evidence and to have a decision made about who wins and who loses. The reason that arbitration came into existence was efficiency, and because a typical court case in employment can take 3-4 years before there's a decision. And over that period of time, many hours of attorneys at a then very high cost. Arbitration typically is something that can be handled within 9 months at the fastest, probably, to a year and a half, 2 years. So you lop off about half of the amount of time it takes to get to resolution in a typical case, which means you lop off about half as much of the cost in terms of attorney's fees. So it's that efficiency that has driven the rise of arbitration, but it hasn't been without its detractors. So I wanted to talk a little bit about the history, and it does now look like the slides are working. Gosh, I hope so. So initially, we'll start with how it all began. We have a constitution in this country, and the Constitution says that we have freedom of contract as a constitutional right. We might have at some point had that. We don't anymore. So it's still in the Constitution, but the idea of freedom of contract is not exactly what it was when the founders put it in the Constitution, far from it. But when we did, essentially, parties could decide how they wanted to resolve their disputes when they just agreed how they were going to resolve it, and off you went. That led to commercial arbitration, where we first had arbitration significantly, business-to-business arbitration. And in business-to-business arbitration, one of the hallmarks of it was that you would have a neutral arbitrator, and therefore the parties would split the cost of that arbitrator. And that historically is how arbitrations were done. Well, with that and the development of arbitration agreements by crafty employer lawyers like me, we would write all different types of terms to an arbitration agreement because, again, we had freedom of contract. We could put whatever we wanted in there, and if the parties agreed to it, that's what it was going to be. So going back many years, 20 plus years ago, we would do things like shorten the statute of limitations, put a cap on damages, exclude punitive damages, many things that essentially put the employer at a significant advantage in using arbitration versus being in the court system. Well, as you might imagine, the plaintiff's lawyers for employees did not like those agreements at all. And the plaintiff's bar in California is one of the strongest lobbying organizations in Sacramento, and have been very successful both in the court system and in the legislature at fighting against arbitration agreements. The most recent success they've had is AB 51, which we'll talk about in a minute. But because of those fights in the court system over the last 2 decades or so, the courts have definitely cut back on what an employer can do in drafting an arbitration agreement. And the bellwether case for that came out in 2000 called Armendariz versus Foundation Health. And in Armendariz, actually, I think I have a slide on that for you. Yeah, there you go. In Armendariz, the California Supreme Court said, well, we'll let you have arbitration agreements. We'll let you take employment disputes out of the court system and into a conference room with a neutral arbitrator. But we're only going to let you do that for employment claims where certain conditions are met. And those conditions are a certain amount of discovery, fairness in the procedure having to do with the arbitrator being neutral, etc. and the employer must pay the cost that are unique to arbitration. Um, if an employee files a lawsuit in the Superior Court, they pay a filing fee, but they don't pay by the hour for the judge or the courtroom. In arbitration, you typically are paying by the hour for the arbitrator and possibly for the conference room that you're using. And the court did not want those costs to be passed on to the employee because it would discourage employees who might not have the financial means to pay those costs. So if you have an arbitration agreement today and you're an employer, you can have it, but you have to pay the costs of the arbitrator and the costs that are unique to arbitration. So that was what Armendariz stood for. And at that point in 2000, really all you could do, there were no more employer advantage tricks. All you could do is move from being in the court system to being in a conference room. Now, the plaintiff's attorney still hated it because they are giving up their jury. Instead, an arbitrator makes a decision, not a jury of 12. And without the jury, there's less likelihood that the plaintiff's attorney hits the jackpot award, the $6 million for hot coffee from McDonald's in my lap type awards. And they want those. It's all about money. So they've continued to fight against arbitration, even though post Armendariz, post 2000, all you're doing is moving the form. The employee can get all the same remedies. They have all the same protections. They just don't have that jury. So that's the post Armendariz. The attacks have come having to do with whether agreements are procedurally or substantively fair. There's a contract principle called unconscionability, and an arbitration agreement is enforceable so long as it's not unconscionable, so long as it's not coerced to be entered into, and so long as the terms of it are substantively fair. The other battle that's gone on in the last decade is having to do with class action waivers and the Private Attorney General's Act, or PAGA. California courts have typically been sort of anti-arbitration. So as cases have moved through California, the California courts have said, no, you can't have class action waivers. But there's a Federal Arbitration Act, and the federal courts are very favorable to arbitration, in particular because the Federal Arbitration Act is favorable to arbitration. And so what has happened is those cases on class action waiver and other cases that are adverse to arbitration as an idea have been moved up to the federal court system and eventually to the U.S. Supreme Court. And each time the U.S. Supreme Court says back to the California courts, no, you're wrong. They can do this in an arbitration agreement. And so we do know that a class action waiver is valid and enforceable in an arbitration agreement, but we only know that because we had to go up to the U.S. Supreme Court to get that determination. And the determination that the Federal Arbitration Act preempts the attempts that California may have to put the kibosh on arbitration. With regard to PAGA, it's still an open question because the California courts have said that you cannot have a waiver of a PAGA claim in an arbitration agreement. But at some point, that will also likely go up to the U.S. Supreme Court, and the result may well be the same as it has been, the federal court saying, no, California, you're wrong, they can do that. We'll just have to wait and see on that. And we'll talk in a minute about how AB 51 is going to play into that. Another example in the last decade of this political adversity to arbitration agreements was the Fair Pay and Safe Workplace Executive Order of 2014. President Obama put in a rule that if you were a federal contractor, you could not have an arbitration agreement with your employees unless it was a purely voluntary agreement that they entered into. You could not condition the employment on signing the arbitration agreement. Now, it was new because prior to that, and for anybody who wasn't a federal contractor, the courts had made it clear that you could make signing an arbitration agreement a condition of employment. So, for instance, you could say, look, if you don't sign this agreement, then you can't work here. That was absolutely permissible. That's called a contract of adhesion, a take it or leave it. But it was permissible to do that, both in California and federally, having to do with arbitration agreements, until the Fair Pay executive order in 2014. That only applied to federal contractors, mind you. And in any event, you'll note on the screen it's been repealed. President Trump repealed that particular regulation, so it no longer applies. But along comes AB 51 this year, which essentially does the same thing. Essentially says you cannot have an arbitration agreement as a condition of employment. Okay? So even though going back to 2000 and the Armendariz decision, there was no employer advantage to arbitration, it's been continued to be attacked very aggressively by the plaintiffs' attorneys because they want to be in front of a jury, they want to put on a show, and it doesn't really matter what the law is at that point. It's can you put on a show and a little magic show for the jury and get them to give a big award or be very upset about something. That's where the big dollars are for them. And so that's where we are. Let's talk about AB 51 now. So AB 51, before I get into the key rules, actually, let's get ahead of ourselves. AB 51 was signed by Governor Newsom in October, but it's not the first time that the California legislature, the Assembly and the Senate, have passed bills that essentially outlaw arbitration. They've been slightly different forms, but the attempts in the past that were passed by the legislature went to Governor Brown, who vetoed both of them that had passed all the way through. And the reason that he did, right in his veto message, is these are going to be preempted by federal law, so there's no point in me signing them. Apparently, Governor Newsom has a different take on that. Maybe he doesn't care. Maybe it's just political. Maybe he thinks because there's slightly different wording in AB 51, there's a chance that it'll make it through the court system. Not really sure about it. But there's a significant chance that AB 51 will eventually be ruled by the federal courts to be preempted by the Federal Arbitration Act. And we'll talk about that a little bit more in a minute. So let's dig into AB 51. Here's the key provision. A person shall not, as a condition of employment, continued employment, or receipt of any employment-related benefit, require an applicant or employee to waive any right or forum, blah, blah, blah. What does all that mean? Essentially means this. A person shall not require an applicant or attorney to sign an arbitration agreement. Okay? Note that it says a person. So arguably, there could be individual liability because it doesn't use the word employer, which you'll see in a minute. It does use in other parts of the statute. But with regard to the prohibition of requiring somebody to sign an arbitration agreement, it says a person. So one of the many questions that'll come out of this is, will there be individual liability for a manager, supervisor, or an HR person who hands an arbitration agreement that's non-voluntary to an applicant or employee? We'll just have to see. But the bottom line is you can't require it, which essentially means you can have arbitration as long as you can demonstrate that the employee or applicant entered into the agreement voluntarily. Other key rules in the new statute: employers may not threaten, retaliate, discriminate, or terminate individuals because they refuse to sign an arbitration agreement. So remember, it has to be voluntary. If you put it out there and you ask people to sign it and they say no, you can't retaliate against them. The other thing that they did in the statute was look ahead at some of the things that have been utilized in contracts of adhesion in the past. And one is called an opt-out procedure. And essentially, what you do is you say, here's the agreement. If you don't want to be part of it, then you have to affirmatively opt out. You have to take some action to not have it apply to you. That is a way in which you can create contracts and agreements with people. But in the case of arbitration agreements, you cannot use that kind of a procedure. That will not meet the definition of it being voluntary to put it out there and then require employees or applicants to opt out or do something else affirmatively to get out of it. Another key rule or provision of the agreement is that it doesn't apply to post-dispute settlement agreements. So let's say you're in a case and an employee's filed a lawsuit and that's being defended, and ultimately you decide you're going to settle that with the plaintiff and the attorneys work out a settlement agreement. In that, you can have an arbitration provision, and sometimes there are arbitration provisions in those. It also does not apply to a negotiated severance agreement. And I've underlined the word negotiated because it creates a problem separate and apart from arbitration, or could, for companies that or organizations that have template severance agreements that they use. And if the severance agreement contains arbitration provisions, or even if it doesn't, if it just contains waivers of filing claims, etc., which they do by definition, and it's not negotiated, it runs the risk of being invalid under AB 51. And many times severance agreements are not negotiated. You terminate an employee for a variety of reasons. You decide that you are willing to provide some severance, and you say, hey, employee, we're terminating you, but we will give you 3 weeks of severance. If you want that severance, here's the agreement that you need to sign. It's not negotiated at all. And so arguably in that situation, you'd have a problem with the waivers of claims that are in the severance agreement, and oftentimes the whole reason you do the severance agreement in the first place. So if you have a practice of using severance agreements, you want to examine that, and you want to examine how to avoid having AB 51 make your severance agreements invalid. Another key provision, and this goes with almost every new employment law or regulation that comes into effect in California, there's the, oh yeah, and if you violate any of these new rules, the plaintiff can get damages and their attorney's fees. So in this case, if you had a situation and you had an invalid arbitration agreement or one that does not comply with 51, the plaintiff can get the injunction, which means court says you don't have to go to arbitration. They could get any damages that they might suffer. Typically not going to be probably too big of an issue. But a big thing is going to be they're going to get their attorney's fees. So in that situation, you end up paying your own attorneys, the defendant does, and the plaintiff's attorney's fees. So a tag on that, again, is added to all the statutes, or not all, many of the new statutes, to create even more leverage to try and get people not to go sideways to what the new rule is. So another thing to note about AB 51 is it applies to contracts for employment entered into, modified, or extended after the end of this year. Now, because of that, and because it's clear that if you're going to be in compliance with 51, that if you enter into an arbitration agreement in January of 2020, that arbitration agreement is going to have to be a voluntary arbitration agreement. You cannot say to an applicant or employee, here's our arbitration agreement. If you want to work here, you have to sign it. If you don't want to work here, that's fine. You just have to go get a job somewhere else. That's a contract of adhesion that is not voluntary. After the first of the year, that won't work. You're going to have a voluntary arbitration agreement. What has happened then is, for some people that don't have arbitration agreements, there's been this rush. Well, I want one, and I want it as a condition of employment, so I'm going to do it now. I'm going to do it in 2019. And I think for many people that still may be the right answer, but I will point out to you that word extended after the end of the year. Now, typically, when you think of a contract and a contract extension, it means that there's a further communication and an agreement to extend an existing contract. There's an interaction between the parties. But I don't know ultimately how a court might interpret what that means. Could it mean I entered into an arbitration agreement with my employees in 2016, and it was a condition of employment, it wasn't voluntary, and it's indefinite in duration. Am I extending it in 2020? I think the answer is no when you review contract law principles and case law. But anytime there's a word that's not defined in a new statute, there's always a susceptibility for it to be interpreted by a court and interpreted in a way that can create consequences that are contrary to what you think. So I think if you want to have that condition of employment arbitration agreement, and you could more than likely still do it in 2019, and it would be valid in 2020. But I would be remiss if I didn't point out to you this language that talks about a contract for employment that is extended, and whether that might be a contract that we entered in 2019 that is extended into 2020. There's an outside chance well, that'll likely get attacked that way, but there's an outside chance that a court could interpret it that way. The other thing that's interesting about this particular provision is you'll note that it applies to contracts for employment entered into, modified, or extended. Now, it's interesting because that language, I think, could be attacked from the defense side, is I didn't enter into a contract for employment. I only entered into an agreement, provided the arbitration provision is separate from an employment contract. I entered into an agreement on how we're going to resolve disputes. So I guess what I'm getting at is there's much to be decided and much for attorneys to fight over with this stuff. It's not like we know exactly how this is all going to play out when the dust settles. Another key rule out of AB 51 is this, what they intend as a savings clause in it. And I referred previously to the Federal Arbitration Act. As I said, previous arbitration cases have been overturned when they get into the federal system and up to the Supreme Court, and overturned because the Federal Arbitration Act essentially provides protection for arbitration agreements. And arbitration, the Federal Arbitration Act says, states, if you can regulate contract law, and if you make rules having to do with contracts generally, we will respect that. But if you make rules that are specific to arbitration agreements or anti-arbitration, then they are going to be preempted. The reason I point this out is I don't know how the state of California is going to be able to show that AB 51 isn't an agreement or isn't a new law that attacks arbitration specifically. Now, it doesn't use arbitration as a word in it, but it also is not generally applicable to all contracts in the state of California. And as a result, I do believe, and many other people who've opined on it believe, that ultimately AB 51 is going to be overturned by a federal court. Of course, it is different than previous attempts, and so there is the possibility that it survives and that a court says no, it still is okay under the Federal Arbitration Act. One of those unsettling uncertainties that unfortunately I can't solve for you. But I think the best guess of most people is eventually it will be, AB 51 will be preempted by the Federal Arbitration Act, even though it's got this language in it. Now, the other thing to point out about the Federal Arbitration Act, if you are in the transportation industry, you may well be outside of the Federal Arbitration Act, which means it's a much greater likelihood that AB 51 is going to apply to you. So if you're in transportation, interstate transportation, you would need to check to see, are you subject to the regulations that kick you out of the Federal Arbitration Act? And if so, then California pretty much has free reign over you. The other thing that I didn't put in the PowerPoint, but if you're in the financial industry and regulated by SEC. The SEC has its own sort of arbitration for financial professionals. There's a specific exclusion in AB 51 for those types of arbitration. So if you're in financial and you're regulated by SEC, you may not be subject to AB 51. All right. So how many of you, if I could see your hands, how many are saying, oh my goodness, what are we going to do? That is certainly the question that we have been asked repeatedly from clients. What do we do? I wish I had a pat answer for everybody. I don't. But I do think the choices are fairly simple. No, I shouldn't say that. That's not true. I will try to make them as simple as possible. And then you're just going to have to kind of decide for yourself. And again, if you need further sort of guidance that's more particular to your facts and background, don't hesitate to let us know. But here's what I see the options are. First of all, you do nothing. Now, you could do nothing from a variety of different perspectives. Maybe you don't have an arbitration agreement, never have, don't have it, don't want it. Okay, don't do anything. Nothing for you to do because you don't have an arbitration agreement. Again, I recommend arbitration. I think it's the way to go. I could give you many reasons why it's good for the organization and good for the employees. And the main reason is speed and cost. If you can get disputes resolved quickly, it's good for human emotion, it's good for business and the economy of the organization, because you are cutting out thousands and literally in many cases hundreds of thousands of dollars in attorney's fees. And so if you can cut that out, it's good for everybody. If you can cut out being in the court system for 4 years and the disruption to an organization and all the employees of the organization, and get that done in half the time, everybody wins. Why is it good for all the employees? Well, if you're paying defense lawyers like the Holden Law Group or others hundreds of thousands of dollars to defend an employment claim, if you didn't have to do that, where would that money go? In most organizations, it goes back into the organization and can be used for new equipment, expansion, salary increases, bonuses, you name it. Anyways, long-winded there. You can do nothing. What if you have an arbitration agreement now? Well, if it was one that was not a condition of employment, not a take it or leave it situation, it was truly voluntary, you don't have to do anything. Well, what if it was a condition of employment and it was required by the organization for new employees or applicants or employees to sign the agreement to continue their employment? So it was, again, the condition of employment, take it or leave it situation. You could still opt for number one and do nothing, because there's a significant likelihood that AB 51 will be ruled preempted by federal law. Now, if you choose that path, what happens if a dispute arises? Plaintiff's attorney comes knocking on your door in 2020, says, I represent one of your employees and you're a bad employer and we're suing you. What do you do at that point? Well, you could pull out your arbitration agreement, say, here's my arbitration agreement, we're not going to court. Well, you're likely then going to get into a legal battle, attorneys will, over whether that arbitration agreement is valid or not given AB 51. And you might be on the cutting edge of a case where the courts say, no, AB 51 is preempted by federal law. Lawyers will be making all those arguments. If you don't want to get embroiled in that at that point, Or if you get embroiled in it and you decide you don't want to go farther for whatever reasons that might exist at that point, you just walk away from arbitration and you're in the court system. It was like you never had the agreement in the first place. Now, there is a potential risk, remember, going back to those key provisions, that there was this violation of the law if you tried to impose that kind of an agreement, a conditioned agreement, a take it or leave it agreement. Could you be subjected to damages for doing that? Could you be subjected to having to pay their attorney's fees for the battle over the arbitration agreement? Yes, maybe. So there could be a cost to that. But those could all but, for the most part, as a practical matter, be gone if at the outset, when it happens in 2020, you just say, hey, you know what, we're not even going to pull out our arbitration agreement. We're just going to go along to court. So those are the options under one, do nothing. The other option is to implement a new agreement. There could be a variety of reasons why you would want to implement a new agreement. Maybe you don't have one, never have had one, but like the advantages of arbitration in terms of speed and cost, and you'd like to get one. Okay, well, then what you can do is, you got two choices there, is the A and B. You can do a mandatory condition of employment, take it or leave it type of arbitration agreement, but do it before the end of the year. More than likely, that agreement will be valid in subsequent years. There's that little hitch that I told you about that word extended and how that may get litigated, but more than likely, your agreement is going to be valid moving forward into subsequent years. And we would be able to argue it's not extended. It's just an agreement that was in place in 2019 and it remains in place indefinitely. So that's an option for those who want to have a condition of employment. They want everybody covered by an arbitration agreement. The other option, obviously, is to have a voluntary agreement. If it's voluntary, it complies with AB 51 and you have no problem. Now, keep in mind, if you decide to go the voluntary route, you're going to want to be very careful in terms of how you communicate and document the process of the employees entering the arbitration agreement. Because when you pull that agreement out in 2020, 2022, whenever it is down the road and want to use it, dimes to donuts, the plaintiff's attorneys are going to attack it no matter what. And what they're going to attack is it wasn't voluntary. And so you'll want to be able to show very quickly and easily through your evidence that it was voluntary. So there was another page that is missing here. I apologize for it, but I'll just tell you what it was, and that is, if you're going through an arbitration process of getting employees to sign arbitration agreements, whether that's something you're going to do now between now and the end of the year or down the road, you want to be methodical about it. The first step for it is to clearly decide what your policy is going to be. What is the policy for arbitration for your organization? Who does it apply to? Everybody or just some? Is it voluntary or is it a condition of employment? Why are you doing it? You want to know those things, because the second step then is to have clear communication with your employees about it. Transparency, education is critical in terms of making it a positive for everybody as opposed to a potential negative because people don't understand what it's really all about. Then you're going to want to have a well-written arbitration agreement. You do need to have a written agreement that is signed by the employee that delineates the decision by both parties to arbitrate. You'll want to make sure that that agreement complies with all of the requirements from the Armendariz decision and other contract principles. You are absolutely need that agreement to specify that it is governed by the Federal Arbitration Act. Otherwise, you're at risk of just being exposed to AB 51, without that preemption argument. You then want to give the employees the opportunity to review and carefully consider the agreement before they sign the agreement. You're going to want to document the process and education that you went through. And then you're going to want to have good record retention of all of that so that if you get challenged on your arbitration agreement down the road, and I can tell you that if you have an employment case and then the other side is a plaintiff's attorney, they don't want arbitration mostly. So if there's any holes for them to shoot at, they'll shoot. But if you have done your steps correctly and you've maintained the documentation and evidence of that, it's a much simpler process to get the plaintiff's attorneys to go away and not fight on that issue. Okay? So that's what I've got for you. And I now am going to take questions if we've got some. So let me pop open my questions. I've got I have some comments. So you definitely have opinions on this. Definitely share those. Let's see if I can got any questions. Okay, one sec. Apologize for my ineptness. This has been there's a question about whether you could have in an agreement a choice that's given to the employee or applicant about whether they want to proceed to arbitration or the court system. Yes, you could certainly do that. And in essence, that's what you're doing if you have a procedure that makes it voluntary for an employee to enter into an arbitration agreement with you. If they don't enter into it with you, they're choosing the court system. You could certainly spell that out in the agreement. If you wouldn't need to do that necessarily, though, you would more than likely spell that out in really plain and simple terms in your education meeting and in the education process so that employees understand what it is, what arbitration is, and what rights they have and what rights they don't have. Okay. Next question. Next question is, if we gave our arbitration agreement to our employees at some point in the past, and we did not make it a condition of employment. It was not a take it or leave it. They could decide whether or not they wanted to enter it. Can we now then make it mandatory or a condition of employees for all new hires? And the answer to that is yes, you certainly can. You can change your, let me back up. Unless you have made some agreement not to change your policy or practice with arbitration, yes, you could do that. And in most cases, most employers don't have a specific agreement saying, hey, we made this agreement that arbitration will always be voluntary at this company. In the absence of some sort of an agreement or policy statement like that, yes, you could have it be mandatory for your new hires. Will the slides be made available to us? Certainly, we can happily give you the slides. Sure, no problem. Just if you just send an email to me or to Melissa or anybody, we'll make sure you get the slides. How do you demonstrate that an arbitration agreement is voluntary? Well, that's a good question, and it goes back to the slide that I'm so inept today. I must apologize. Did not come up before the question slide. The way you do that is you first delineate what your policy is. And once you have that, that's the first piece of evidence. Do you have to provide that to the employees? Not necessarily, but we're going to want to be able to establish what the organization's policy is with regard to arbitration. And getting back to that, one of the last questions, it could be that for employees prior to November 13th, 2019, arbitration was voluntary, but now it's mandatory. That's a policy statement. We know the position, okay? That's step number one. Step number two is to get the well-drafted arbitration agreement, okay? That's a piece of evidence number two. In that agreement, there are going to be things that make it clear that it is not a condition of employment and that the employee will not be retaliated or applicant will not be retaliated if they decide not to sign it. Okay, so that's piece of evidence number two that you'll use to demonstrate. Then there's going to be an education process. How you go about your education process is going to, it's going to vary for different organizations. It may not be too difficult to pull everybody together and have a big team meeting where you discuss it. I think that's the preferable way to do it because you can explain the value and benefit to everyone as a whole to arbitration, and you can really make it a positive for the organization and create positive energy around it and remove negativity that some people sometimes associate with arbitration. You'll have documentation of what was communicated through that education. You might have handouts that you provide to employees. You may have a script from it. Maybe you even record it. Again, these things will all depend upon what's right for your organization, but you'll be able to demonstrate that we went through an education process so that the employee could make their own decision. Then you're going to have whatever communication goes with the presentation of the agreement, also a piece of evidence. And then we're going to be able to show that we didn't require somebody to sign it on the spot. And so that we'll be able to show that they had time to consider it. And I think that's probably about all you're going to need in terms of being able to demonstrate that it was voluntary. Okay, let's see. Okay, these are some more statements. I agree with all of you. Okay, there was a question in here that came in maybe before I got to it. But it says, does arbitration apply, or does this apply? Does a new law apply to arbitration agreements entered into 2018 and prior? And the answer to that would be no, with the exception of that little wrinkle that I talked about of, well, whatever does the term extended mean? My guess is that it's going to be interpreted that an agreement that was entered into any time prior to the end of this year will continue to be valid, even though it wasn't voluntary, even though it was a condition of employment. It looks like we had a problem with the sound at one point, so I apologize to everybody for that. And that looks like all we have in terms of questions. So I thank you all. I hope you have a great rest of the day. And if you have any further questions, don't hesitate to call on us. Take care.